we move on to a set of startups which are under grave threat thanks to the imposition of 28% GST on their business. And we're talking about the gaming startups. And they are in the news repeatedly in the recent past because of tens of thousands of crore rupees worth of tax notices that they've been sent by the Central Board for Direct Taxes. And these companies are now taking them to court and they're not willing to pay these. We had Dream 11 taking matters to court. Dream 11, which has tax notices worth 25,000 to 40,000 crore rupees. And then you have everybody else, the top gaming startups in the country following suit. To understand what is going to happen going forward, we have some special guests joining us. We have Mr. Asish Philip Abraham, partner, Lakshmikumaran and Sridharan attorneys now joining us. Ashish, thank you so much for taking time out to be with us here on this edition of Business Plus this afternoon. Now, this has been in the news. The quote that's often reported is, quote-unquote, game over for online gaming startups. That's how, because from 8% worth of tax to nearly 28% worth of tax. That's going to change their business model completely. It's going to destroy their business model is what they believe. And now all these tax notices coming their way, they're being taken to court. Do you think they will get any kind of relief from courts because of these retrospective tax notices?
Thanks, Madhuri. The gaming space has been seeing a lot of changes in the last 6 months, be it in income tax TDS or new intermediate rules, and coming to GST. The GST, it has been in the news because of the shockers notice issued to a GameScrap and Karnataka High Court setting aside the demand. So what is interesting thing in the notices is that prior to amendment which is made in the July 2023, whether GST is liable to be paid, because the law was amended to tax it from in a different manner from 1st October 2023. A new regime is coming. Prior to that, whether online games or skill are covered by the definition. The earlier matter of Karnataka High Court is pending in the Supreme Court. So when the GST Council took a decision, the Council was aware of the fact and the Council said that let the Supreme Court decide the fate for the past period. So it will be interesting to see what fate GameScraft matter will have in the Supreme Court in relation to the shockers notices issued. So as the law stands today, only games related to chance, which are betting and gambling, are taxable. Everything else was excluded. Now, definition was changed to include games of skill. So retrospectively applying the shockers notices is difficult under the current legal position. So we feel it's difficult unless the matter which is pending before the Supreme Court, a different interpretation is taken by the court, which is different from the view taken by the Karnataka High Court.
Right, and these writ petitions are going to come thick and fast going forward, but you have the Supreme Court that stayed Karnataka High Court ruling listed for the 10th of October. This is with respect to petitions in the Bombay High Court. This is the Dream 11 battle specifically, so to speak. You have multiple companies joining now. The question here is that it's always about whether retrospective taxation, how much validity has, in terms legally speaking, because you've had this happen with the telecom companies as well. But as a term, retrospective taxation just doesn't sound right.
So as a principle, after the Vodafone judgment, the government as a tax policy has decided they will never be going for a retrospective taxation. Always it will be prospective. However, the government is taking a position that whether the current interpretation of the law as stood always was is it a clarificatory amendment or retrospective? The government position seems to be the way they filed the appeal, etc. Seems to is the amendment is clarificatory, which according to us is not correct. When the definition itself, the law itself was changed, it's a new substantive change. Since being a substantive change, it cannot be said clarificatory and applied retrospectively. All the gaming companies where the shockers notice will be issued in similar lines to GameScrap, no other option than to approach the various high courts where they are situated to bring a logical end to this dispute.
Right, bringing a logical end to the dispute. But it's always, the question here is that another morality question, is it a game of chance or is it a game of skill? And in correspondingly, taxation being decided on the basis of that, correct?
Correct. So to explain give background. Today, actionable claims other than betting, gambling, and lottery is excluded from GST. After October 1st, new amendment, games of skill, action claims in related to games of skill is also taxable. So prior to that, unless it is games are being proved, it's a games of chance, it's not taxable. So all the games which is played today in India are games of skill, which is permitted in terms of the Public Gambling Act. Games of skill are not prohibited.
Right. Stay with us. We also have Mr. Girish Vanvari, founder, Transaction Square, and former national leader tax at KPMG, joining us. Mr. Vanvari, talk to us. You have Dream 11 filing a writ petition at the Bombay High Court against tax notices worth 25 to 40,000 crore rupees. Hasn't sent its way. For now, only MPL is yet to be sent tax notices. All top gaming startups and companies in this country have been sent tens of thousands of crores worth of GST notices. Do you think that these companies can find recourse through law?
I think this is going to be very, very interesting. Is this retrospective or is this prospective? Is this clarificatory or is it something which is new in the act? The law will really pan out on this, like it happened in Vodafone's case, wherein we had the similar kind of issue. But yes, everybody will rush to the courts because it is existential crisis. The amounts are very huge. The amounts which we are seeing in various news flashes, is that the real amount, or is it now reduced significantly because at least the amendment is 28% of the money put in and not 28% of the money which is continuously with the profit reinvested, rebet, so on and so forth. So really it is going to be a very interesting few days ahead for all the gaming companies who will rush to the courts to see what can be done, what stake can be got, how can this all be dealt with.
Right. Point being is that at this stage you have certain judgments coming in from Karnataka High Court, which gets stayed by the Supreme Court, and the Supreme Court has now put a hearing for the 10th of October. What do you expect from the Supreme Court on the matter?
I think that will be very critical. Do they endorse this, or will they change it? If the judgment of Karnataka High Court falters in the Supreme Court, then we have a serious issue with everyone. Serious issue. So all eyes will be on 10th. I think that's the date.
Right, that's right. The 10th of October. I want to know your expectations of what are the possibilities that are there in front of the Supreme Court for this entire thing to progress as far as the legal system is concerned for these cases.
I think if Vodafone has to be followed, then the outcome will be different because the prospective law will prevail. But if Vodafone gets challenged, contradicted, because Supreme Court will look at the Vodafone judgment as it decides this. So really the Supreme Court will be very critical, and it will be interesting to see what arguments are attached for the retrospective amendment in the Supreme Court arguments, because that is something going to be very critical in this whole outcome. So I'm going to be interestingly watching this, and I'm not the Supreme Court to say what will Supreme Court say, but as a professional will be eagerly watched as to how this thing moves forward.
Right. Of course, we will also be keeping a track and hope we get you back on the same day on the 10th of October to discuss the findings or the decisions that made by the Supreme Court. I also wanted to ask you, okay, that's as far as the validity of the tax notices is concerned. But what about the tax itself is concerned? You know, that debate between game of skill versus game of chance is where this whole thing hinges upon.
Yeah, but I think a game is a game, and that's what it will tend towards. So going forward, game of skill, game of chance, I think game will be a game. But can it be 28% on the total amount put in the platform is something which we will have to see from a past perspective. So I think, I have no problem with the law as it goes ahead, because that's the lawmaker, and they decide to treat a particular thing in a particular way. And everybody is clear as it gets into that business. But for the past, how will the law look at it? How will the courts look at it? Something which will be very interesting for all the gaming companies who are going to be dealing with this in the next few days.
Right, because Gamescraft right now, you had it, you got a good message coming in from the Karnataka High Court, good decision coming in from the Karnataka High for Gamescraft, whereas Dream11 and other companies are still waiting for what is going to happen with them. But in the meanwhile, are you really saying that the outcome of the taxation on telecom companies will have a huge impact on the outcome of this particular case of taxation on online gaming companies?
I would not exaggerate and say a huge impact. I would say it will be a good reference point.
Okay.
As you look at the retrospective part of it, it will certainly be a good reference point.
Okay, and are you not, unless otherwise the Vodafone case is decided, you're not expecting a finality on these matters as well?
I am hoping so, because there are so many business models which will shake with this past litigation. Going forward, obviously, they will recalibrate to the new law. But for the past, how will they deal with such huge amounts? Some solution has to be found between the government and these companies.
All right. We will leave it at that. Mr. Girish Vanvari, founder Transaction Square and former National Leader Tax KPMG. Thank you so much for taking time out to be with us. And of course, Mr. Asish Philip Abraham, partner Lakshmikumaran Sridharan attorneys. Thank you as well for taking time out to be with us.